America in the early 1950s was a nation living two realities. On paper, it was the land of freedom, equality, and opportunity. In songs and speeches, people called it the greatest democracy on earth. But if you were black, you knew a different America, an America where the color of your skin dictated where you could sit, eat, live, and go to school. In much of the country, laws known as Jim Crow laws enforced racial segregation. These laws didn't just separate people, they sent a clear message: you are not equal. In Topeka, Kansas, a little girl named Linda Brown lived with this reality every day. Linda was just 8 years old, full of energy and dreams like any other child. But unlike the white children in her neighborhood, her daily walk to school was a long and exhausting journey. She had to leave home early, walk through muddy streets and cold winds, cross dangerous railroad tracks, and then take a long route to the city's black-only elementary school. Meanwhile, there was a white school just 7 blocks from her home. It was modern, bright, and filled with new textbooks. But Linda Brown could not step inside. The law in Kansas, and in many other states, said black children and white children had to attend separate schools. This was the reality of separate but equal, a principle that had been the law of the land for over 50 years. Back in 1896, the U.S. Supreme Court had decided Plessy v. Ferguson, a case that allowed racial segregation as long as the separate facilities were supposedly equal. But everyone knew the truth: black schools were not equal. They often had hand-me-down books, crowded classrooms, broken furniture, and fewer teachers. Generations of black children were growing up with fewer opportunities, all because of the color of their skin. Linda's father, Oliver Brown, was an ordinary man, a welder by trade, and a father who wanted his daughter to have the same chance in life as any other child. He could not accept that his little girl had to risk her safety every morning just to reach a school that society said was good enough for her. He believed that the Constitution, the very foundation of America, promised something better. In 1951, Oliver Brown, along with 12 other black parents, agreed to join a lawsuit organized by the NAACP, the National Association for the Advancement of Colored People. Leading the charge was Thurgood Marshall, a brilliant lawyer and strategist who would later become the first black Supreme Court justice. Marshall understood that this case was bigger than one family or one city. He was challenging the very heart of American segregation. The case, Brown v. Board of Education, moved through the lower courts, but the judges there felt trapped by history. They cited Plessy v. Ferguson and claimed that separate schools were legal. But Marshall was determined to reach the Supreme Court, the only place where the chain of injustice could be broken. In 1952, the case was finally heard by the United States Supreme Court. Imagine the scene: 9 justices in black robes, the grand marble chamber, and the weight of history pressing down. On one side, the attorneys for the school boards argued that segregation was simply the way things had always been. They claimed that it caused no real harm to black children. On the other side stood Thurgood Marshall, calm but burning with determination. He spoke about the real lives of black children. He presented evidence from psychological studies, including the famous doll test, which showed that segregated education made black children feel inferior. When given black and white dolls, many black children preferred the white dolls and described the black dolls as bad or ugly. Segregation, Marshall argued, was not just a separation of facilities, it was a wound on the soul of a child. The justices debated for months. They knew their decision could shake the nation. Some feared that overturning segregation would bring resistance, even violence. But Chief Justice Earl Warren, appointed by President Dwight D. Eisenhower, worked to unify the court. He believed that the Supreme Court had to speak with one voice. Finally, on May 17, 1954, the decision was announced. The courtroom was silent as Chief Justice Warren read the historic words. Greater than, in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. With that unanimous ruling, the Supreme Court declared that racial segregation in public schools violated the 14th Amendment of the Constitution. Linda Brown and millions of children like her had won the right to equal education under the law. But the story didn't end with the decision. Across the South, resistance erupted. Some states closed public schools rather than integrate them. Angry crowds formed outside schools where black children tried to enroll. Families who dared to follow the court's ruling faced threats and harassment. Yet, the law had spoken, and a new chapter in American history had begun. The victory in Brown v. Board of Education became the spark for the civil rights movement. Just 1 year later, Rosa Parks refused to give up her bus seat in Montgomery, Alabama, leading to the Montgomery bus boycott. Dr. Martin Luther King Jr. rose to national prominence, inspired by the belief that justice through law was possible. And in time, the Civil Rights Act of 1964 and the Voting Rights Act of 1965 would bring America closer to the promise of equality. The courage of one little girl, her father, and a small group of determined families reminded the world that the law can be a powerful force for change. Today, when children of all races and backgrounds learn side by side in classrooms, they are living proof of the battle fought by the Browns and the countless heroes of that era. The story of Brown v. Board of Education is more than a legal case, it is the story of a nation confronting its own conscience. It teaches us that the fight for justice often begins with ordinary people taking extraordinary steps. One father, one daughter, one lawsuit, and a decision that changed America forever.